Here we go. Good afternoon, everyone. We do have a quorum, so let's call this meeting to order. And first up, we have House Bill 721, Representative Rice.
Thank you, Madam Chairman. Thank you, committee members, for being here today.
Did anybody sign up?
Appreciate the opportunity to come before you.
Okay.
Madam Chairman, if I might,
I don't know.
I would like to ask two of the principals who are with me that can explain the circumstances of the bill to come on up with me, if that would be
That'd
okay.
be fine, Chairman Rice. All of us?
People that are coming forward is Dr. Kevin Sheehan. He's in the blue blazer. And the practice administrator is Don Kirk. He's also here with us, and they'll be able to explain further the circumstances as to why the bill is brought and the outcomes that have occurred as a result of this. House Bill 721 is really a short bill, and it frankly deals with one thing having to do with the composite medical board's ability to provide information in the cases of a civil trial. In what the bill basically does is to say, and you'll find it down on line 59, is that the board's going to be required to release information that substantiates that the licensee, in this case Dr. Kevin Sheehan, has reported an act of omission of another licensee to the board, which is basically a whistleblower type of situation. And basically all this says is that they're going to be allowed to release that information in the case of a civil trial that the licensee who rendered the complaint gave to them. So here's the circumstance. Dr. Sheehan provides a complaint about another doctor to the medical board. The medical board communicates back and forth, but they have it under investigation, don't take action at that particular point in time. The doctor that's in question in the complaint continues to practice. One of the patients that doctor has is treated and goes into what I'll call a vegetative state, for any other words that I can say. A civil suit is brought, and it includes the entire practice, including Dr. Sheehan. The case is by the way, Dr. Sheehan obviously is the one who filed the complaint. There is no opportunity for Dr. Sheehan to present the fact that he even filed the complaint with the composite medical board. That information is not released. Ergo, the decisions rendered against all of the defendants in the case, and Dr. Sheehan winds up with about $1 million judgment against them, and having nothing to do with the situation except for the fact that he reported this doctor prior to the time that this procedure ever took place. And if in fact, and which is a fact, that the evidence of the reporting of this particular doctor had taken place would have been necessary to relieve the action effectively against Dr. Sheehan, and his partners in the case. So that's the essence of the bill. Now, the composite medical board has gotten back to me, and you got a piece of paper on your desk that says what's the old information in the bill, and you see it at the top, and then the new right underneath it, the proposed language. I am fine with the proposed language, except on the second line where it says the board can release the correspondence. If you just struck that under Legislative Counsel's comment to me earlier, that should be struck. But I think that covers it. What it does is to say that it restricts it to the licensee that gave the information is the one who can request the information when there's a civil action. So that's what the bill is, Madam Chairman and members of the committee. I'd like to turn the mic over to Dr. Sheehan and Mr. Kirk, and if they just comment on the circumstances.
Right. Chairman Rice, before we go on, as I told you, this is a hearing only, and I have the language in the amendment, and I will take that under consideration. I do have one question, though, since we're basing this on the medical board, on the fact that there was no response in the medical board. The medical board informed me that they gave, Dr. Sheehan, gave you an affidavit saying that between you and the board person you talked to, and saying that did exist and that you had talked to somebody. Is that correct?
They gave a one-paragraph notice that said that I had contacted them prior to this, but the judge deemed that inappropriate and inadequate, stating that they needed a witness, and the board absolutely refuses to allow agents to testify.
Okay, but they did try to give you what?
Originally, I went in as a confidential informant on the case, and originally we went forward, and once the suit came to me, we asked the board to release the information. They said that they could not do that. I subsequently sent in a letter giving legal authority for them to release confidentiality, and they again said that it was not in their policy. They simply could not do that. Apparently, this made it all the way to the AG, who was sympathetic but had nothing that he could do about the situation. Eventually, the board gave me a one-paragraph note that said he had contacted us about this situation, but no specifics. We provided phone records as well to the judge that said that I had contacted the agents and proved that I had contacted the agent, but again, that was deemed as inadmissible and inadequate, and so the judge allowed the case to go forward.
Dr. Sheehan, I mean, I don't, and you can go ahead and talk, but, and with all due respect to the lawyers on my committee, I think lots of us have problems with the decisions that some of the judges make, and that would be the judges making that decision, not the board.
Can I make one comment about why he got sued? He got sued because...
If you'll just hold on just a minute, I'll let Dr. Sheehan go ahead. Okay, go ahead and tell us what you want to tell us about the case.
All right.
Go ahead, Dr. Sheehan.
Basically, the case involved a patient named GB. I began working for Dr. Dougherty in 2007 as an employee. Shortly thereafter, I became concerned about his competency level and safety level. I notified the board on one previous occasion where he had a bad outcome, and other times after that. I told the board that I really was concerned about patient safety. I've never turned anybody else in before. I didn't like doing it, but it became basically a mandatory thing for me to do. Based on that, there was a couple of investigations to Dr. Dougherty. He maintained his license. Eventually, in September of 2008, patient GB went in for a routine epidural steroid injection on her low back, and she basically has never woken up, and she's got permanent and irreversible brain damage, and I believe she remains in a long-term health care facility. The case is ongoing against Dr. Dougherty at this point in time. Dr. Dougherty, the insurance company, the plaintiff's attorney offered a settlement originally of about $2 million. Dr. Dougherty and his attorneys ignored that and did not accept it. Based on that, the attorney involved went ahead and sued everybody else within the surgery center, including me, and I was only an employee. The allegation was that I had not done anything to stop Dr. Dougherty from practicing medicine. And I was told by the board that there was nothing else I could do other than simply report him to the board, and at that point in time, it was up to the board to deal with him. After the GB incident, the patient was basically rendered in her persistent vegetative state. At this point, Dr. Dougherty did have his license undergo a suspension, beginning, I believe, in approximately October of 2008 and extending until February 2009. Then the board gave him back his license after a thorough investigation. Sometime thereafter, Problems continued within the practice. It eventually went into receivership, and me and another doctor opened up another practice. Because Dr. Dougherty did not settle, I was subsequently sued, and everybody else in the practice was sued. What happened after that was, let me think now, my insurance, the allegation was that I had not done anything to stop this. And so I provided what documentation that we could regarding phone records and told them that I had contacted the board and done everything that I was legally allowed to do. Apparently that did not matter, and they said they needed better proof of that. The board said that they could not turn over any information from a confidential informant. I turned in a legal authorization for release, and again they said no. I went to the AG, and he apparently eventually somehow got a single paragraph that was fairly nonspecific and said that he had contacted us regarding this case, and that was it. That and based on some phone records, and the judge deemed that inadmissible. What I needed was the entire case and, if possible, an agent to testify, which is what the judge basically wanted. Because of that, my insurance company came to me and said they were willing to settle on my behalf for $984,000. Now, of course, I had nothing to do with the case. I never saw the patient, never even met the patient, never met any of her family members. I have never seen the patient. I still have not. I was not in the same building, and I was only an employee, and I had turned the doctor into the state board. What I needed was the state medical board to turn over all available information, not just simply a single paragraph letter that was nondescript. I wanted all of it, and if possible, a witness. They refused to do this. So I am now permanently tagged with a very large lawsuit on my record and permanently escalated malpractice premiums because of that.
Okay, you weren't just asking, let me clarify this, you weren't just asking for more proof that you had turned him in, you were asking for everything that they had found in the investigation.
I wanted everything that I had turned in.
Okay.
I wanted specifics. That's what I had to have. Without it, the judge allowed the case to go forward. So this one paragraph, nondescript, nonspecific letter was absolutely inadequate on the board's behalf. Now, based on that, after the fact, I understand the board's position. They had policies and procedures that they had to follow, so it was kind of a perfect storm. I just happened to be the guy that got caught in the middle. Based on that, because of the settlement that was coming forward, I did not have the right to refuse settlement on the insurance company's behalf. Under legal advice, I was told that I could go to court. However, if the settlement came in excess of what my malpractice was allowed to pay, being $1 million, I would be responsible and liable for the remaining portion of it, which potentially bankrupt my family. So I couldn't do that. I had to allow them to settle, but they didn't need my permission to settle in the first place, so they just went ahead and did it. At this point in time, I was sued for not stopping Dr. Dougherty from practicing medicine, and he continues to practice medicine in the state of Georgia.
Okay. Does
Let just Todd comment on you.
He mentions insurance premium. Dr. Sheehan paid last year $11,223 in his insurance premium. As a result of this case, it jumped to $27,773 this year. It took us 3 days and about 10 affidavits to get it back down to $12,000. And I don't know if any of you know what goes on the profiles, on doctors' profiles. If you go on the composite board, every doctor has a profile. Now listed in Dr. Sheehan's profile is a malpractice suit that was settled for the amount. Now, I will tell you as an administrator, I don't know if anyone ever reads disclaimers on there. They just say, oh, you got sued. Well, I don't think I want to come see you. And he did nothing. And that's what you basically live with. And what I was going to say, he already said. He got sued because he refused to turn him in.
Okay. Well, I don't mean to sound unsympathetic. My husband died recently. He was an MD. He was sued 40 years ago when he was covering on a weekend and told a patient that he was too sick to have a certain treatment. And they sued everybody. And the patient went home to New York, lived a year, and then the family sued. And Tom, he was forced to settle also, and for 40-something years he was mad about it, Dr. Sheehan. So I'm not unsympathetic with you on that issue. And because I've lived through, and if anybody ever mentioned a lawsuit, he got mad about it. Okay, we have questions. Representative Watson.
Hey, it's over here. Thanks for coming down. Appreciate y'all doing this. Certainly a lot of questions and a lot of concerns. I too have empathy for your position. I think I was sued about 12 years ago, and I was a covering physician also. And it took about 9 months to get and depositions and so forth, to get my name dropped off the suit also. Of course, my name was dropped off and yours was not, apparently. Can you do some, just give me some details? What kind of physician are you?
I am practicing physician. I'm licensed practicing physician here in the state of Georgia. I've been here for just over 20 years. I am board certified by the American Board of Anesthesiology. I have their subspecialty board certification in pain management, and I'm also board certified by the American Academy of Pain Medicine.
Okay, so you anesthesia, do pain management, do epidurals and so forth.
Yes, sir.
Procedures. And so you were in a group practice, presumably we're talking about 3 physicians, or
yes.
What do we? And the physician that was sued employed you. Is that
yes,
what we're saying?
Yes, I was an employee at that time.
Employee of that physician. Okay. All right. And just a couple other details. You stayed in practice with him for. You reported him, and then you stayed in practice with him for how long?
I started there in 2007, and we started the new practice in 2010. There was constantly, the other partner and him were always in a negotiation to potentially split the practice off. His other partner, Dr. Luther Rollins. Me and him got along very well, and we were planning on trying to separate the practice out, and so I stayed on at that point.
So you were an employee for how long?
2 years.
2 years, and
Not
then
quite.
Were you to be a partner after that, or?
He offered partnership. I refused it.
Okay, and you practiced in the same surgery center. Is that what the? Is that where you get drawn in?
It was an unusual situation. Dr. Dougherty, I think, understood that he was not practicing probably at full capacity, and what he would do was split the schedule, so I was never in the same place at him at the same time. That was another issue that I had with the case, and that I never had any first-hand information regarding Dr. Dougherty. All of it was hearsay, and then I had to look at some x-rays that were done and some outcomes that came through, but I never actually watched him. And so when I was sued, I said, well, I've never seen him actually practice and have a problem. I've just seen the results of some of it. And based on that is why I turned him in.
So you turned him in, and then the suit came up later for a different patient.
Yeah, he had one bad outcome where a patient had a stroke. He said he was putting an epidural in the cervical spine at one level, and the x-rays clearly showed it being at another level, no dye on the film, and the patient had an embolic event.
Gotcha. And that's what you turned him in for?
That, as well as numerous concerns by other staff members.
And explain to me why you couldn't. I practice medicine. I mean, our malpractice is, I presume, is going to be the same clauses in there, though I'm sure they are different. If I want to fight it, I can take it. I can take it to the court. And you elected not to. I think there's always that clause in there that they had the ultimate say so. I may get some clarification from some of the lawyers here, but and you couldn't testify that I had sought, I had turned him into Composite State Board of Medical Examiners and so forth.
I was deposed, and I was deposed and had all that information that came out. Yes.
And y'all chose not to go to court, and you settled.
I didn't choose not to. The insurance company chose to settle it without me, because once the judge allowed it to go through, they looked at the overall situation and decided it was the path of least resistance. I had no say in the matter.
You had no say. So that was, and your insurance, malpractice insurance, was part of your employment contract?
Yes.
Gotcha. I guess that means you need to pay attention to the employment contract when you sign it, doesn't it? Your practice administrator's nodding his head over there. I don't think mine does, but I have had a contract like that before. I understand where you're coming from. You were referring to the National Practitioner Data Bank, or you referring to Composite State Board of Medical Examiners, the public record? Either one of you able to answer that?
Both.
Both. And that means that you have had a settlement of $900-something thousand, and is that the only settlement you've ever had?
Yes.
Okay, and your insurance did go from 11 to 27 back down to 12 with negotiation.
Yes.
Right. Okay. I guess the thing that's sort of bugging me a little bit is that you were practicing with a physician that you felt was not competent.
I was.
And you continued to do that because of why?
Because I had no other job opportunities.
You're a board certified anesthesiologist.
Well, like I said earlier,
Where's this? What city are we talking about?
in Smyrna, Sandy Springs. There's a variety of reasons to it. All this was occurring in 2007, 2008, and the economy had just gone very bad. I was living on the south side of town, and Dr. Dower, like I said, there was another physician in the practice, Dr. Rollins. And after I had gotten there, I had talked about leaving, but Dr. Rollins wanted me to stay on. As he was,
Gotcha.
he was a,
So
he was a partner
a
there.
possible business opportunity with
Correct.
the other guy in the group.
Correct. And there was
Now,
always talk of that split.
You ever had your partners otherwise reported to Composite State Board of Medical Examiners?
I'm sorry, I'm not sure what you're
You ever
asking.
had any of your other partners reported? I mean, listen, I'm in a big group. I've had a partner reported.
Not that I'm aware of, no.
I will tell you, he had to go and testify in front of the Composite State Board of Medical Examiners. I mean, it was a rather unpleasant experience for him, and it was totally unjustified, and it was a vengeful attack. I just have a tough time. The confidentiality there is for a reason. There seems like there are a lot of circumstances that are moving parts here. From your contract that you had with the Composite State, with your contract that you had with the malpractice insurance company, your insurance. Mm-hmm. To staying in practice with a physician that you felt was incompetent because of basically you may have a business opportunity with the other person, and then breaking the confidentiality of the Composite State Board of Medical Examiners, which personally I don't know the percentages, but I suspect that when physicians are reported, it may be 90%, it may be 10%, the good and the bad. My experience is that the Composite State Board, if anything, errs on the side of protecting the patient and not the physician. But I understand what you're saying. It sounds like there are a lot of moving parts to this.
I would disagree with that. I would say that there are a lot of extenuating circumstances what got to it. Ultimately, the issue is that my concern is that I don't think that there are people that are more concerned about questionable physicians than good physicians, and because it's damaging to all of us. And if the composite board wants to maintain a good relationship and allow us to police ourselves, they're going to have to be on our side to help police that. Now, I was quite resistant about bringing this out and even discussing this with Representative Price, because I understand that if it gets out in a more public forum that I provided whistleblower status to a physician, and then the state medical board did not come to my benefit when a civil action was taken against me, the likelihood that any physicians in the future are going to start reporting people back to the medical board is absolutely non-existent. So if you want to continue to have and maintain good relationships with the physicians and the medical board in order to police ourselves, then you have to allow physicians that if they require information released from the medical board based because of civil actions being taken against them, we're not asking for everybody's information, simply ours, what I have provided.
Right.
Otherwise, you will never get physicians to police themselves again. They will not come into the medical board. At the very least, the medical board has to make it absolutely clear to anybody who comes in as a whistleblower that says, we will not testify and we will not release any information, whatever you turn in. And I am absolutely certain at that point in time that every physician will turn around and say, and act just like Sergeant Schultz, I know nothing.
Are you finished? No. I do have
Yes.
one question, and before I go to the next person. What information had you supplied the board that you could not replicate? I mean, you said there was I mean, if people had x-rays or other people had told you about things, it seems like those people could have been, I'm not a lawyer, subpoenaed by your lawyer. If there were x-rays or things, you could have gotten a hold of them. So what did you supply the board that you could not have replicated and supplied in your...
It's not an issue of me replicating the medical records. What my legal obligation was is to turn him into the medical board and provide adequate information for the medical board to an inquiry into the physician. That's what was not adequately given up by the medical board. All I wanted were all the records, the phone records of the agent that I spoke to, and the agent to actually put down and suggest this physician has been in constant contact with me on numerous occasions, and he has done everything that is legally within his authority to do.
Okay. All right. Who's next?
Madam Chairman, just one other point from Dr. Watson, Representative Watson's comments. The board's told me about 1,500 different complaints during the year about doctors. The great majority of them, as you might expect, coming from patients who want to see a doctor have his license lost based upon an outcome that they didn't expect, very, very probably. So the great majority of them, Dr. Sheehan's comments about whistleblowing, there's a certain number of doctors who own up to the threats that are implied in the whistleblower type of situation, and they go ahead and they do it anyway for the good of the patient. And I think from that standpoint, he's to be commended.
Okay, Representative Kidd.
I think Dr. Watson has most of them, but a couple. Were any other members of your group sued besides you?
Yeah, some of the nursing staff was. Amazingly, I was just an employee, and the man who was actually the other partner within the group was not actually working there at that point in time. Dr. Dougherty had him escorted off the premises at one point in time by a police escort. It was a rather bizarre situation, which is one of the reasons that I ended up staying, is that the other partner had left the practice and basically begged me to stay until he could negotiate a withdrawal and reestablishment of the practice, and that happened early on. Since he was not there, he didn't get sued. Some of the nursing staff has been sued, and some of those cases are ongoing at this point.
So, if I'm correct, and I agree with y'all's comments a few minutes ago about other doctors not testifying if they're going to get sued. But you're the only other member of the group that got sued because one of your partners was a bad apple. Is that right?
I was the only other pain management physician working there at that point in time. There was another physician in the practice, Dr. Orr, and I have no idea why he wasn't sued, other than that he's a neurologist and doesn't do interventional procedures.
And so you were sued because you didn't take action, or were you sued because you did take action?
I was sued because the allegation was that I did not take action and didn't do enough to stop Dr. Dougherty from practicing medicine.
Right, okay. Madam Chairman, I'm under the belief that in most of the practice acts, there is language in there, and it's been a number of years, obviously, since I read the Medical Practice Act, obviously, but and some of the others, but that encourages people to come forward and indicate whether it's a bad dentist or it's a bad MD or it's a bad chiropractor or a bad anybody, and basically gives immunity to those people who do so in good faith. And it seems to me like if a member of the profession can't do that in good faith, then something's wrong.
I think Betsy's looking that up right now. So, to review it, because I'm not certain. I'll be back to you in just a minute, Representative Kidd.
I'm through.
Okay, Representative Kaiser.
Oh, thank you for having me.
I'm not a doctor. I've never been sued. Luckily, I can't imagine being in a position of Dr. Watson or Dr. Cooper having been sued. The concern for me that's not lost on me here is that the difference in this case is that you actually did take preemptive action.
Yes.
And so I know this is a hearing, and if it weren't, I'd make a motion for due pass today. But my concern is exactly what you say, that folks, it's almost like we're discouraging. I'm not questioning the medical board's decision about this particular doctor, but it does heavily concern me that we went in, within the confidence, but the point at which you needed information which you provided them confidentially and were not allowed that information is just, I'd be sitting right where you are. It's really angry.
Who's doing it?
But what about, did your lawyer not compel the board to give that information without you having to go to court and risk losing your families?
Apparently not. This is, when I initially talked to Representative Rice about this, that was my exact concern, was that if somebody is going to act as a whistleblower, they have to have some kind of protection or confidence that if should civil action take place against them, that they can get access to that information to protect themselves. And if it comes out, this is exactly what I told him, is that if that comes out, if I was to go more public and go to the Atlanta Journal and say, look, this is what happened to me, I could shut down any physician cooperation with the board by the next day. It would never happen again. Given the circumstances of this particular case, I probably could.
The insurance companies give these doctors lawyers, but they don't work for the doctors. They work for the insurance company. He had to get his own lawyer. We had to go out and get another lawyer so that it would give him advice at the same time, but the case was so far along. Because these lawyers work for the insurance company, they're going to settle this case if the insurance company says settle it, and they're going to try and tell these doctors, because I've seen it happen time and time again, that you can go through with this, but here's what's going to happen. But the lawyers assigned to help these doctors, and I'm sure Representative Cooper can say this, and any other doctor on the board, they represent the insurance company. So, I mean, that's exactly what happened here.
If I could, Madam Chair, it's not a question that whether there's truth in that or not, I don't know, because I'm not personally aware of that or been part of that, but, you know, I mean, it begs the question as to whether or not you could get a lawyer who could compel the board to give the information that was clearly his information, preemptive action taken by him, then who would go to court and risk another lawyer not being able to compel and lose your family's finances?
Apparently this went all the way up to the Attorney General, and there was nothing he could do about it either. Apparently see the statute of their policy. And I understand the board's position. I've worked with the board. I've worked with the board for probably 10 years. I've done numerous peer reviews for them, and I've done presentations for them for the National Association of Drug Diversion Investigators. And so I've always had an excellent relationship with the board. I'm one of their physicians that they would call and ask to do these things. And so when all this came up, it was really pretty shocking. Like I said, at the very least, if this cannot be changed, then there should at least be, at a minimum, any physician who does decide to come forward has to be informed of what the rules are.
Okay. Representative Hawkins.
Just a couple questions for you.
Yes, sir.
Make sure I've got this timeline straight. Had the medical board already released, well, had they come to a decision about the physician, the one that was in trouble? Had they gone over his case and then decided he was not guilty of the charge or whatever, and reinstated his license by the time this court case had come about, or were you in the middle of this when they were still making that decision?
The incident that finally got his license suspended occurred in September 2008.
Mm-hmm.
He was subsequently, his license was suspended from October 2008 until I believe February of 2009.
Okay.
He had a prior incident about a year earlier, which I discussed earlier, which is an embolic stroke, which was believed to be up to him, which is what prompted my initial.
So when you were requesting this information, was it during that time when he had his license revoked?
No,
Or, no.
I was not party to the lawsuit until 2010.
So then my question is, he was not being reviewed by the board at that time. That case was settled, right?
His license was suspended, and after investigation, they reinstituted his license with,
Right.
with a variety of restrictions on it.
Right. So I guess where I'm going to with this is, what I see is a problem here that if a physician, even yourself, is accused and then found to be innocent of the charge, would the board or should the board release any pertinent information to that investigation and make that public if you have been found not to be responsible.
You're not comparing the same things here.
Well, I'm getting to that. What you're asking for is just your testimony and the fact that you turned the information over.
Correct.
So pursuant to that, then, why could your attorney not provide that information to the court on his own? I mean, didn't you have records or showing that you had sent this into the board, or is there some kind of legal hand tying with that also?
The phone that I was using was a cell phone that I was using was company issued, and it turned out that as several people knew, that there was some spyware on the computer. So all the conversations that I had with the agent involved were done by my home phone, and of course, since it's a local call, there was minimal records of that. What I also did was I copied off what medical records that I could of a couple of the cases that were involved in the situation.
So when you're reporting this to the board, it's all by voice and not
Absolutely.
paper?
Yeah,
Not paper trail?
Right, I was not leaving a paper trail. Didn't want a paper trail. I did not want to turn him into the board, you understand. Turning him into the board was about the least pleasant thing I've ever done
Sure.
as a physician.
Sure. But you did.
But I
But we
did.
just didn't have a paper trail, and that was
Correct.
part of the problem in this situation, isn't it?
I did not maintain. There's a paper trail at the board.
Outside the board, there was no paper trail.
Correct.
And if there had been, maybe this would have been inverted, you think?
No, because I still have to prove that I contacted the board and that the board took action based on my contact with the
Okay.
board.
All right. No further questions.
Okay. Did the complaint actually say that you were being sued because you did not take enough action?
Yes.
It stated that he failed to take action to stop the doctor from doing the procedures. So,
This happened in Fulton County Court?
I think so, yes. Fulton County Court.
Okay, Representative Henson?
Thank you. You said that your insurance company settled. Did they settle and then advise you that they had already settled, or?
No.
Okay.
They told me that there was intention to settle, and they would like my agreement to settle, but that they didn't need me to agree. They would just like for me to agree. And so, given the circumstances that this is a winning case of the plaintiff, quite bluntly, they were going to parade me in front of a jury in Fulton County and show a mostly dead person, and I was going to lose. Regardless, because ultimately the board was not going to release this information because they couldn't via statute. And so I had no defense other than I needed the board to step in. And so they asked me if I would agree to settle, and given the circumstances that if I did not, that I could go into family bankruptcy, I really had no options.
Well, thank you for working with Representative Rice and coming before our committee. Appreciate it very much.
Thank you for having me.
Representative Peak?
You're not on.
No, no.
Thank you. Maybe a direction to the chair. Did I miss it? Is the composite board weighed in on this? I mean, are they supportive of this change or not supportive of this change?
I'll let them.
Okay. I'm just kind of curious.
I
Well,
think
only
the
thing I
answer
can-
is no.
Yeah, the answer, well, they came to me today with this modification that they had agreed to.
Okay.
And so that's what's represented in your folder right
Right.
now. So whether you call that agreement or
Yeah.
not agreement, we have
Okay.
we have isolated on this. There are a couple word changes that Legislative Council has recommended, but basically it's basically what
Okay,
we're
yeah.
attempting to get at right
Would
now.
love to hear from them. And anyway.
Representative Pack?
Thank you, Madam Chair.
Are you on?
Yes. I'm on, right? Okay, line 51 to 58. And I'm a lawyer, so I'm going to take a look at this a little closer. It says
Got it.
that except as provided in D1, right, that the results of any investigation whatsoever shall be reported only to the board. and the records of such investigation shall be kept by the board. Right? Then it says you can't release it. Now that's the provision. But your 59 on, I have trouble with two things. One, what does it mean to the greatest extent possible? What is that?
Well, in terms of I think it qualifies itself by saying copies of correspondence between the board and licensee and any related documents of the board substantiating such licensee has reported an active omission of the board. I mean, I think that clarifies what the extent is.
Okay. Then what is the any related documents of the board? Does that include the report? Because I would imagine the report would say so-and-so doctor had reported.
But it goes on to say that such licensee has reported an act or omission of another licensee to the board. I mean, so, you know, it could be a timestamped document that says that they, or a call that says that they, or something that record that the composite board keeps that says there has been this contact about this subject. Doesn't necessarily have to go into into the particulars of the case.
That's the concern that I have, because let's say I'm an attorney for the composite board, and this request comes in, and I don't have any guidelines to see what is in fact any documents that substantiates a report of the act. So I would rather see like specific. If you're talking about just correspondence from the reporting physician, that's an easy thing. But what they do with the information, it starts getting into, you get information that certainly will incorporate the fact of the report. And how is the board, composite board, supposed to delineate what is and what should not be disclosed?
Well, the board has the opportunity to redact anything that they feel remains confidential and is to the disadvantage of the person, the licensee that's being reported. I mean, that's in the same section. It's on the next page. It's on line 64. So the board has the opportunity to redact any information that they want to and that they feel breaks the confidentiality barriers that they have set up themselves. I will also tell you that this language that they support, well, that they have brought, and I assume they support it since they brought to me the language, has also been checked by the AG's office. And they're also in agreement with this language.
That doesn't give me too much comfort, but
well, it's the best I can do under the circumstances. If you got a proposal, Representative Pack, I'd be. This is a hearing. We'd certainly be open to making any changes you saw that would be more clarifying.
Glad you asked. Let me work on it.
Right. Okay. Representative Randall, apologize you weren't beeping.
Yeah, this
For
thing
making
here
you
needs
right.
to be fixed for. I've still got a disconnect here. I'm just trying to figure out. You were deposed,
Yes.
correct? And you still felt like that the documentation would have resulted in a different outcome.
Absolutely.
And so I'm just trying to figure out where's the disconnect here. I mean, you know, I agree. Let me just say, I agree that in cases like this, the board should submit whatever you sent to them for several reasons. Time stamping, it shows a period of time where you continue to try to be responsible. So for several reasons, I totally agree. But I'm just not understanding the disconnect here as to how there was such a big difference with what you deposed and why the discretion of this judge the outcome wasn't different. Do you have any clue of how that happened?
Well, like I said, originally, the original settlement offer from the insurance company, I was not named in the original suit.
Oh, okay.
And then the insurance company and Dr. Dougherty did not accept the settlement offer. And once the time frame ran out on the settlement offer, and then the plaintiff's attorney basically sued everybody else he could get his hands on.
Okay.
And I was there. And basically because I was the doctor with the biggest insurance policy, I was a great target. I was deposed because I did not stop him from practicing medicine or warn the patients thereof. But I'm not legally allowed to do that. Considering the fact that he continues to have his medical license, if I had tried to stop him or warn patients about that, I would have been subject to a civil suit by Dr. Dougherty that he would have subsequently won.
Right.
So I was basically, and when I talked to the agents about this, the agent in particular, the way the board works, to the best of my understanding, the way this agent has discussed it with me, every time I contact her, there's a note entered. She enters something in that file that says, I spoke to him, he has these concerns. I sent over records, I sent over pictures, and all those things get entered into the file.
Mm-hmm.
All I wanted was the records that I had spoken to this agent. I wanted the records that I had, and many times as we discussed things, I wanted the medical records that I sent over. But because none of that was supplied, and all I got was a little one-paragraph blurb that was non-specific from the medical board, which, I appreciate the board doing that. And let me be clear about something. I can understandably, I hope you understand, that I can understandably get a little bit worked up about this particular case upon occasion, because I feel like I did everything that legally I was allowed to do, and I ended up on the short end of the stick. I understand the board's position. I do. They were limited by statute, and they basically did what they can do. Mm-hmm. But I just got caught in the crosshairs in a bad situation, and I hope that going forward that I'll continue to have a good relationship with the board, and I'll continue to do peer reviews for them. But quite honestly, only if something changes in the rules. I won't expose myself to this risk again. I would have been much better off saying I don't know anything.
Oh, I certainly understand that. My other question is, thank you. My other question is for you, Representative Rice. Regardless of the proposed language or that the board has supplied, what do you think is the due burden? I mean, what's the issue?
I'm sorry?
What do you think is the issue with them just as is with the legislation? What are the real issues with the legislation? Because when I looked at the difference between the language, it wasn't a whole lot. What is the big deal?
It's the issue of the licensee. The qualification is it only goes to the licensee. There's a general qualification here in the language that I have. This only goes to the licensee who reported, basically.
Who reported it? Okay.
Okay.
Thank you.
Representative Hawkins.
I asked you some pretty pointed questions, and you gave some very good answers. I just want to say I hope you do not give up on this. I hope you come back to this committee once we get this settled.
Okay.
Yeah, because you deserve it. Yeah.
Okay. There is, to answer Representative Kidd, to answer your question, there is whistleblower immunity. It's in 4334(8) of the law. So, Dr. Sheehan, you would be protected from the person that you turned in. So,
But not from a civil suit.
right. That's it. Do we have somebody from the medical board? Come forth and identify yourself.
Hi, I'm LaShawn Hughes. I'm the director of the board.
Well, I have a question. I think they said that you had about 1,500 complaints.
We get 1,600 to 2,000 complaints a year.
And how long have you been with the medical board?
10 years.
Have we ever had a situation like this before that you are aware of?
No.
Do you have any idea why?
Well,
Pardon?
I guess this situation is unique. Other doctors do report other doctors, pharmacists report doctors to the board. We've just never had this situation before.
With 1,500 to 2,000 things a year.
Right.
Does anybody have any questions for LaShawn? Dr. Watson?
There. Thank you, Ms. Hughes. The board will not give him something in writing that he would not give him the information or satisfy the judge that he had obviously taken sort of heroic efforts here in trying to do the right thing, so to speak. And so what was the board's reticent about? I mean, in my opinion, doing a letter with a little bit more details, what's the board's reticent? I mean, he's saying it's either rules or statutes, or what's the concern there?
Well, the board was advised by the Attorney General's office that the information, the letter, the affidavit that we did provide was all that we could provide him.
Because, and the Attorney General said that was because why? Is somebody from the Attorney General's office here?
Complaints or confidentiality?
No, I don't think so. I asked.
Complaints, confidentiality of complaints.
I mean, I certainly understand the confidentiality of this, but he's been sued, and what he's asking for, doesn't sound unreasonable. So we were saying in statute, there's the confidentiality of that?
According to the Attorney General's office, yes. And the board was sympathetic to Dr. Sheehan, and certainly we don't want to do anything to hurt physicians in Georgia, and anything we can do, we want to do that, but we are bound by the statute as it's written, and we were advised by the Attorney General's office that the affidavit that we provided, that he had gotten in touch with one of our former agents, we provided that, and that was all we were told that we could provide.
So may I follow up, please, Madam Chair?
Yes.
So the Attorney General is suggesting that we have a change in law to allow the Composite State Board of Medical Examiners that if another person is sued from a whistleblower status, that we give them the information as much as we can, I think is the way that y'all said it. Right.
It's not, the board is actually opposed to the law, the proposed change, because we don't want to release, if someone filed a complaint on you and wanted information about that, we don't want to open the door to give everybody information about complaints that are filed. Some complaints are unfounded and nothing happens to them, but if it's as written, anybody could request it. And so if the language has to pass, we would want it to be restricted to only Dr. Sheehan could get the information, not anybody that requests.
Dr. Watson, the Attorney General's office, I talked to a representative from them. They are not taking a stance on this. What? Pardon? I can't hear you.
Well, to me, it looks like in the old language versus the new language, it can only be released if someone is being sued. Is that too loose? Is that what the concern is?
Well, we just want the information to be released to the licensees. Like for you, Dr. Watson, if you had this situation like Dr. Sheehan, that the language would allow the board to release it to you, not
to release it to Dr. Sheehan.
Right, only.
So, and now what could he do with it?
We would provide him a true and certified copy of whatever we had, a true and correct, I think is the language, certified copy of the records of the board, and then he could do whatever he sees fits with it. But we don't want anybody to be able to have that ability to have a peek into the complaints.
I mean, if you have 2,000 complaints a year and you sanction probably, 200 physicians a year, I mean, that's a matter of public record, correct?
Right.
So what's that, 10%? Somebody do the math for me. So 10% of the complaints are of earnest and require sanctions, and the others may require other disciplinary aspects. So you're looking at it from a confidentiality standpoint, and you're looking at it as whistleblower. Okay, thank you.
Okay. Representative Stevenson.
My question was answered. It was with our agent.
Okay, thank you. Representative Clark.
Madam Chair. My question was for the composite board. Sometimes
Kaiser's on.
I'm not sure if I'm on. Am I on?
Who's on?
I found that many times when I've dealt with large organizations, sometimes they don't actually have a record of I'll ask them to go back and pull up the records, and sometimes they don't have it. What kind of records do y'all keep, and do you have a detailed record of this?
We keep licensure files for 100 years and complaint files for 60 years. So we have them.
And so the person taking the call is taking detailed notes
Well, he spoke to an agent. I think it was a friend of his that he knew that worked with the board. One of our former agents, Adrian. She doesn't work for the board anymore. So he provided information to her, and according to, I just heard he said that she took detailed notes about what happened. The agents, when they go out and investigate a complaint, they write up a report based on their investigation, their medical records, and things like that. So I don't know if, there's more information for him to get based on her notes.
Sorry, I'm trying to understand this. The agent was working at that time, though,
Mm-hmm.
but
Right.
no longer is now.
Right.
Okay, and we don't know if there's notes from that conversation or not.
Well, it would have just been incorporated into her report to the board. So it would have been up to her to include what she thought was pertinent into her case write-up.
Yeah. Ms. Hughes, get formal here, even though I call you usually by your first name. Could that agent have been subpoenaed by the court to testify?
The agent could have been subpoenaed, but it's up to the Attorney General to decide whether we get to testify based on where we are with our complaints and whether that information is considered confidential.
Did Dr. Sheehan's lawyer ask that agent, or did they ask that she be subpoenaed?
I don't know.
Yes, but I'm not
You
certain.
can't really answer that.
I don't know.
They did, but the attorney told us, or he told me that they weren't going to let anyone report.
Okay. Representative Henson.
Thank you. I'm just trying to get something clarified. Reports, correspondence, and all of that could be turned over to the individual. You're saying based on confidentiality, so it all could have been turned over to Dr. Sheehan under our current laws. Is that correct?
No. Complaints are confidential. Everything about the case is confidential until the board takes an action.
But if he's saying the things and it's part of his reports, why can it not be turned over to him? That's what I don't understand.
It's incumbent against the complainant to keep copies of everything that they have.
But how can he get copies of something if in fact he's reporting it and the agent is the one that's doing up the report? So how and when would he ever have the ability to get a copy of it if the agent does not give him a copy or the board does not make available a copy?
Right.
I mean, seriously, you're saying it's incumbent on him to give a copy, but yet he doesn't know what the agent put into the report.
Well, I'm talking about the information that he provides to the board.
But if she's writing it up, if it's verbal, then he has no idea what she's putting down.
Right.
Is that correct?
That is correct.
So therefore, how is he ever supposed to know what she puts down?
He could have put it in writing to the board, but complaints are confidential by law, it's by statute. So
who are they available to?
the complaints are available to the board members to make a decision. Representative from the Attorney General's office, employees of the board. It's like this. It's not unique for medicine. It's like this for all licensing boards. Complaints are confidential, and we don't release. We have a lot of people call us constantly filing a complaint, want a copy of it, want a copy of who's filed a complaint against this doctor or that doctor, and I'm sure it's the confidentiality to protect the physicians. Dr. Sheehan's case is very unique, but we're trying to protect the physicians from people getting information about complaints that are not valid.
I guess the question is, are you trying to protect Dr. Sheehan or are you trying to protect the other doctor? This is where I'm thoroughly confused. If Dr. Sheehan's trying to get information to protect himself, where's he supposed to get it?
He has to discuss that with his attorney.
But his attorney couldn't get it.
Representative Henson.
I'm sorry.
Okay. Representative Kaiser.
Thank you, Madam Chairwoman. I'm Chairman Rice. I'll start calling you Price.
He has a much better retirement plan than I do.
Clarify something. Was the testimony earlier not that it's the interpretation of the
No, well, there's, by I think it's pretty clear in the statute that they're not allowed to, it's all confidential, and it's only available by the board making a decision to allow it to be. So that's it.
May I ask Ms. Hughes a question? Ms. Hughes, I had the pleasure of observing a hearing recently with one of the examining boards, and I know the amount of work that you guys do. I have great respect for it. I'm just curious what the specific opposition is to this language change, because I understand what you're saying about the Attorney General, but it appears from the testimony that the Attorney General is limited by what is in current statute. And to change, I'm concerned about who specifically the board is worried. I feel like the language is very clear. So
We're concerned that if you open up the language to allow anyone to have the complaints, the language is written, or our suggested language would have allowed Dr. Sheehan to have the information, and he could have went on and maybe or maybe not won his case. We just don't want anybody to be able to have access to the complaints. Only if someone has to get it, the person in Dr. Sheehan's case, to allow him to have it, but maybe not Dr. Watson to get it because he's interested in the case or he has an outside interest in the case.
Representative Pack.
Thank you, Madam Chair. Isn't the fear that once you open up a document in litigation, whoever wrote that document is subject to depositions, and then you get into all the deliberative process of the board? Isn't that the reasoning behind the confidentiality rule?
Right.
Okay. And I have some suggested language here, and I would like your opinion on it.
This is just a hearing, Representative Pack. If you'd like to give that to me later on, you can.
Okay. I was just going to get her feedback on if she likes it or not.
Okay, if you want her feedback.
I was going to move them in.
Well, I'd have to get,
All right.
I'd have to take it to the board for feedback.
Okay. Well, then to the author. It seems to me that if we were to allow the release of some information as a shield to let Dr. Sheehan use whatever information to defend himself against a lawsuit, if we were to adopt the language that the board proposed and condition as at the request of the licensee who reported the act or omission, that should protect whatever concerns that the board might have about everybody getting the information.
Right.
Am I right?
Correct.
But I am concerned about the quote unquote the greatest extent possible, and the words any related documents, which seems to be a little bit too loosey-goosey.
Okay.
Well, the greatest extent possible, if I read this correctly, I just got this about an hour before we started here, is not in their proposed change.
Right. It's in the bill.
It's in the bill.
Right.
That's right. But I've already said that with the change that Legislative Council suggested on a couple words, that I would accept this language.
And Representative Pack, and to the members of the committee, remember, as we said, this language and this protection is in all of the licensing boards. So a change here then can mean a change for the lawyers, for the dentist, for everyone else. Representative Hawkins.
Ms. Hughes, now you said that you have not experienced this kind of situation in 10 years?
No, I have not.
Now, my experience has been, and my colleague P.J. Pack, I think, would probably agree with this, is that we see precedents set in law every day. So if it's happened to this physician, could well happen from now on. Having said that, would the board entertain, or would you be receptive, and I know that you're compelled by the Attorney General, but to release information stating that the physician had made a complaint, not particular details, but at least substantiate that he had made a complaint when it is a civil suit. Seems like this is drawn up very narrow, and it seems to be helpful to those physicians, dentists, and whoever it may be else that would help them when they do bring these complaints. Is that something you think that the board would be open to if it's confirmed by the Attorney General?
Certainly.
Okay, thank you.
Representative Kidd. Okay, pass. Okay, Representative Sharper. Let's make this the last.
Yeah. I just have an overall comment, basically, seeing that this is a very, very unique case. It doesn't look really good as far as the Attorney General or the Composite Board that he requests the information, and he feel that he did give information to an agent, and now is a former agent involved, it make it seem like there was no information taken in from the standpoint from the agent side. And that's just a general comment, but it doesn't look good from the outside. It's looking like there's no information to give him is a reason why he's not getting anything. That's it. That's all I'm saying.
Do you have the actual statement that you sent with you from the board?
I don't. Dr.
Do you have
Key?
the actual statement that they received from them?
No, the attorneys have it.
Okay. I would remind the committee that this is a legal, that we are hearing one side of this story. I appreciate you coming. But Dr. Sheehan, you've been in medicine a long time, and if you've walked with the board, is it not uncommon, and there was a case recently that an attorney had stated that he only took cases where a child was dead and not, they had a much better chance of getting a big award if a child was dead and not just injured. Is it not commonplace for doctors to be sued and for lawyers to sue everybody that can possibly be involved when there is somebody incapacitated, such as this lady was, and to go after money from somewhere?
What I can tell you is I was not involved in the initial suit. Until they refused settlement, I wasn't brought up at all.
That's what I'm meaning, to once, so far, and just to get money from somewhere.
That's what they were doing.
I think that's probably. Thank you for coming. I would like to see if you can get a copy of it, what the board sent you, and I'd also like a copy of the subpoena or the refusal of a subpoena from the agent that you told, and from what the Attorney General said about that. If you could just get that for me, I'd appreciate it. So thank you very much for coming and testifying.
Thanks for your attention today, and we hope we can move ahead with it.
Thank you.
Thank you very much.
Sorry. Okay. Thank you, Chairman Rice. Okay, we have House Bill 853. Representative Stover, if you want to take are you by yourself? Well, then you want to take the podium over there? Are you ready?
I'm ready.
Okay, committee, let's listen up.
Thank you, Madam Chairwoman and committee members. Today I present to you HB 853. It is a bill to exclude mental health facilities from the Certificate of Need process. This really is a simple bill, regardless of what you will be told by the other side today. It adds just 2 words to the code section 31-6-47. It has 2 words, and private. Currently in the code section, we exclude state mental health facilities from the Certificate of Need process. What this bill would do is add the word, as I stated, state and private mental health facilities. Right now we have a mental health crisis in our state. We have a mental health crisis in our country as a whole, but especially in our state. There's no facilities locally in many communities in which to put a family member. There's women battling postpartum depression, soldiers battling post-traumatic stress disorder because they have to do it on their own because there's nowhere to get help. If we eliminate the CON process for the mental health facilities, we could increase access to much needed services across the state. But instead, the state of Georgia and DCH and lobbyist groups have put mental health providers in handcuffs and prevented them from opening facilities where people do need much needed access. We need to eliminate the CON process, allow mental health facilities to open in our communities near people's homes so they can get care where they need it. HB 853 is signed by Chairman Earl Earhart, Chairman Lynn Smith, Chairman Jay Roberts, Chairman Tom McCall, and Majority Whip Matt Ramsey. This action is desperately needed in a time of crisis around the state. According to the National Alliance for Mental Health, Georgia received a D in mental health care. The state cannot afford to maintain its facilities and is under court order to disperse many of its members out into private care facilities. According to the U.S. Center for Mental Health Services, nearly 500,000 of Georgia's 9 million residents have severe mental illnesses. In the year 2000, the estimated number of people under 18 with a serious mental disorder living in Georgia, excluding homeless people or people in institutions, was nearly 350,000 people. In the year 2000, the estimated number of children and adolescents with a serious mental disorder was 1,866,000 across the U.S., or nearly 80,000 within the state of Georgia alone. In Georgia, 850 people die every year from suicide. Additionally, 17,000 Georgians wind up in emergency centers for treatments for injuries due to attempted suicide. Nationally, suicide is the third leading cause of death for individuals between the ages of 10 and 19. And mental health access is broken in the state of Georgia, and it's due to lobbyists who care more about the profits of their centers than the people of the state of Georgia. The free market will drive the competition, and it will allow the hospitals who can compete to compete. They will tell you that not-for-profit centers will receive the bottom of the rung patients, the ones that can't pay. They'll receive the Medicaid and the Medicare patients. But the truth is, the best performing facility will receive the patients. It doesn't matter if it's not-for-profit or for-profit. We have a few options here today, fellow representatives. We can continue to let the lobbyists of a few push around the lobbyists of the many. We're the lobbyists of the many. There's more than 9 million people that we represent across the state of Georgia. They represent roughly 1,700 member organizations. I ask for your favorable consideration to the bill, and I know that this is just a hearing, but we're not up for a vote today. But as an economist, I know that the free market will take care of mental health care if we open it up for all. We allow Wendy's and Burger King and McDonald's to compete against each other. We allow Best Buy and other big box stores to compete against each other. We should allow mental health facilities as well.
Okay, questions for the author? Representative Drenner.
Thank you, Madam Chair. And Representative, one of your first statements was about this being a simple bill, and I would beg to differ with you that any bill that regards CON is not a simple bill.
I have the scars and I have the scars to prove it.
And I do understand that, and I appreciate that. Again, the lobbyists are very hot and heavy against any CON changes. We currently exclude hospice facilities from the CON process. Mental health facilities should be as well.
Well, my question is currently, is there any kind of legal action pending that this bill is trying to address?
I am not trying to address any pending legal action. There is a facility in my community that's trying to open, but that is not why I've dropped this bill.
One more question, Madam Chair.
Yes.
Has the Department of Behavioral Health and Development weighed in on this issue?
They have not. The Department of Community Health has weighed in on it, obviously, in other CON processes where they denied mental health facilities.
Okay. Thank you.
Representative Kaiser.
Thank you, Madam Chairwoman. Representative Stover. When I came here 8 years ago as a new legislator, I remember watching Chairwoman and everyone else, Austin, Scott, talk about CON. I've never heard a certificate of need. But in the 8 years, I really am like Carla, believe that it's not a simple bill because it's put in place to have a process. And so I guess my biggest concern is I don't feel handcuffed by any lobbyists. I've heard from a group on one side. I'd love to hear on the other side, and I plan to seek that out. But that other side to me is the Department of Community Health, because it is a part of the process that the CON procedures put in place. So would you just talk a little bit about that? What, you know, I mean, you're coming to us with a bill. I don't know if anyone is here from Community Health to testify, but where are they on this? Because they are the ones burdened with helping us make the right decision in this case.
Well, I mean, quite frankly, they're protecting a bureaucracy that they control. It is hard to get a bureaucracy to turn around and give up power that they currently have. They do receive fees for going through the CON process. The lawyers receive a tremendous amount of fees for going through the CON process as well. It's an extremely expensive process. It's hard for a not-for-profit center that's small to open up and provide mental health facilities because they cannot afford the CON process. Okay.
Representative Kaiser. let me see if, in preparation for listening to this bill today, I understand that there is a set of rules with a formula that that group uses, whoever over in that area, to decide. It is a set formula, and for acceptance or denial. So there is an appeals process, I think, for going on right now. Is that correct?
There is with that particular facility.
With that particular facility, the one in their community, there's an appeals process. And it's my understanding, what I was told, is that if there are extenuating circumstances to why that area that it should be granted that don't fit into that formula, that the appeals process is the place where that is to be presented. And at that point, if you can present why your group should be accepted, and then that's when they consider it, because the formula is very set. And that's how it was explained to me when I talked to the commissioner. I like that.
Well, if I could just respond to that, that's, I think, exactly my point, and I think the comment about it not being a simple bill, that we open it up for private mental health, and then who comes next. And so I just want to be cautious as to who.
Right, and I told the Georgia Association of Hospitals that I would pull the bill if anything was added onto it outside of mental health.
I don't mean to this bill, I mean as we move forward.
Sure, I understand. To the point of the chairman, in 2007, our community actually received an approval by DCH for a psychiatric care facility called Senior Health. And what DCH said at the time was that we were the most underserved region in our state in terms of psychiatric care. So it's hard for me to believe that since 2007, our county is one of the fastest growing in the country, that we now suddenly have psychiatric care covered when no new facilities have been opened in our community or the surrounding communities. The closest psychiatric hospital to the location where our community wants to open one is a 45-minute drive. If you go to the southern end of our community, it's an hour and a half.
Okay, thank you. Okay. I think, Representative Kaiser, right now, we used to be about the third most regulated state for CON. I think with the small changes we made the last time, we dropped to about the sixth, somewhere like that, most regulated states. Some states have totally, repealed their CON, and some of them have the less. But, I would like to clarify something, since I seem to have had problems with the press lately over small rural hospitals and wanting them to close and all. They failed on 2 occasions to put a very important caveat in that I said, and that is, I think we are going to see hospitals change. 10 years ago, the Hospital Association had a meeting, and they had an architect there, and he even said things would change. I think we will see more specialty hospitals. I as smaller communities maybe cannot support a full hospital, and they're about to go under, but their citizens need to have access to emergency care. We might in some days see freestanding emergency rooms with acute care access to it that meets a community's needs, but one that they can afford. I think we're going to see hospitals of a different kind coming, and that may mean there may need to be some changes to the CON as we come down to meet community needs, just for a thing. And I didn't renege on my position that on the second time, and they didn't put that in. So we've got Representative Kidd.
Thank you, Madam Chairman. This is a very convoluted issue. It's not a small one by any means. I go back to 1973, and Jimmy Carter introduced the first certificate of need bill before Georgia had it. Milledgeville one time had 12,000 patients. We have 0 today, mental health patients. There is no place in Georgia today for a mental health patient to go other than to a 16-bed triage center, so to speak. So if the person who was in Georgia court just last week in a divorce child custody case said to the judge, I'm going to kill these people, I'm going to cut them up, I'm going to cook them and eat them, he's crazy. But there's no place to put that person in Georgia. Department of Behavioral Health says, let's put them in a community setting and give them some medication. So I'm in favor of the legislation. I'm in favor of repealing CON in its entirety and let the free marketplace be added. Thank you for bringing the legislation.
Thank you.
Representative Hatchett.
I would just like to, you said that DCH is looking at CONs and they're over CONs, but I am curious as to what the Department of Behavioral Health has to say about how this would fit their plan that they have going forward just in the future.
Okay.
I think it'd be nice to at least hear what they have to say about it. So.
We have somebody from Andrew. Excuse me.
Andrew Johnson. I'm Legislative Director for Department of Behavioral Health. At this point, we have not taken a position on this bill. Obviously, we support any kind of increased access, but we primarily treat uninsured, and this is kind of a little bit out of our realm. So.
Because this one would be for private pay?
Correct.
Representative Jaspers.
Thank you, Madam Chairman. Thank you, Representative Sover. You know, there's a lot of study committees that go on every year, and I know Chairman Dempsey chaired a study committee on mental health. Went all over the state and asked questions, investigated that, I think, very thoroughly. Was this brought up as a part of anything that Chairman Dempsey found? Was it an issue that became evident in her research?
It was not. This is not an issue that was brought up through her study committee that I'm aware of. I don't know the final outcome of that committee.
Thank you.
Who are the signers on the bill?
Well, the top signers on the bill are Chairman Earhart, Chairman Smith, Chairman Roberts, Chairman McCall, and Majority Whip Ramsey.
Okay. People live in more rural areas. And is that Chairman Smith that lives in Noonan?
Yes, ma'am.
In the area?
Yes, ma'am. I seeked out chairmen from all four corners of the state, basically.
Representative Jaspers again.
Representative Stover, we talk about in the rural caucus and different things about rural hospitals and the effect of something like this. Have you thought or done any investigation on how this change would affect our rural hospitals, especially below Macon and all the other places?
Well, it should not affect the rural hospital because they're not providing mental health care. That's the reason I limited it to just mental health. What's happening right now is they're putting people in jail because there's not a location to put them into a mental hospital. The sheriffs have complained on a regular basis that they're the largest psychiatric care provider in the state of Georgia.
Representative Jaspers, if some of the rural hospitals are failing, going to a psychiatric hospital with private pay patients might save them, might help them a little bit if they were repurposed into psychiatric care like that. So, and a freestanding emergency room. I don't know. For Representative Peake. Never can tell.
Ma'am, you addressed my question. I'm good.
Okay. Representative Chokas.
Thank you, Madam Chair. I've got two questions, if that's okay. One of them kind of deals with what Representative Kidd said, and I'm kind of curious since we have somewhat dismantled our mental health institutions in the state of Georgia, especially in Milledgeville, where he represents, because of the lawsuit with the state. How do these community settings, are they under the same CON requirements? I'm curious if that's affected, or how does that work, or you know of any?
For the mental health facilities?
Mm-hmm.
If you want to open a mental health facility, a private mental health facility in any neighborhood in the state of Georgia, you have to go through the CON process.
So in other words, the community health centers that they're providing, the behavioral health centers that they're providing to the state?
Unless they're state. If they're state-run facilities, they do not have to go through that process, and that's what the modification is to allow private in addition to the state.
Well, I'm still somewhat confused, but I'll talk with
If it's
Rusty.
a state-sanctioned hospital, then they don't go through the same process.
Gotcha. All right, and the second one is, and I really appreciated Chairwoman Cooper's statement about the evolution of hospitals and health care in all parts of the state. And it somewhat was alluded to earlier, but maybe we should add as a friendly amendment, and I know this is a hearing, adding multi-specialty ambulatory surgery units to that same.
Oh, don't start a fight. Which hospital association gave you that?
Representative Chokas,
Where's Deb Bailey?
I respectfully will not withdraw my
And
bill
I'm
yet
picking
because
on
it's
you
not
for
amended.
fun, Deb,
But
wherever
there's
you
actually
are.
a bill that does what you said
Thank
that's
you.
floating around the floor
There
right
you
now.
are. I was picking on you for fun.
Thank you.
So, Representative Hawkins.
Yeah, there was a Senate study committee this summer.
Right.
On CON. Did y'all go before that and speak to them?
I have not been before them.
Okay. Because my understanding was they came back with a recommendation of no action on CON at this time. That they
For
were
this
gonna
year,
study it, right, some more.
they're going to do probably something next year.
Mhm.
We have to go through a 2-year process apparently right now because of certain things.
Right. Right, that's it.
Representative Kaiser. She waved. Representative Stevenson.
Thank you, Madam Chair. One question, but I have a comment first. As it relates to those community facilities that's under the Department of Behavioral Health, those are not the same, although they may be funded by Medicaid and therefore are linked to the Department of Community Health. Those are not CON entities.
Right.
We're in agreement. I
Right.
thought that was some confusion there. Second, with the private mental health facilities, what, if you know, is the payer mix of those facilities?
Well, the one that's opening up in my community actually would receive some funding for the, there's 10 beds set aside for soldiers, and some of that will be coming from the federal government.
From the VA?
Yeah, so this is not just a private out-of-pocket type of facility.
Will Medicare be accepted?
I'm not sure of that answer.
Will it then open itself up to be an emergency receiving treatment facility
The
in the rural
information,
areas? If you know.
yeah, I'm not sure. The representative was here earlier. They didn't cover that.
Well, thank you.
Representative Pack.
Thank you. Representative Stover, I think this question will be directed to you. If you know the answer, if not, I'm sure some of the other industry groups. My understanding of the reason you need a CON or certain industry is that by law we're forcing some of these facilities to take in indigent and also for emergency basis and those who cannot pay for the services. I think the trade-off of that was you get this exclusivity of customer base or private pay and whatnot. For the mental health facilities, does the institutions who are not private require to take any patients that are presented to them?
I don't know that any mental health facility is required to take someone that's brought to the door unless there's a court order. I don't know. I'm not sure that they could answer better than I can on that. But you know, I'm sure if someone placed an order in that they had to do it, but I'm not sure.
Representative Clark.
Thank you, Madam Chair. Am I on?
Yes, should be. C7.
I appreciate you bringing this and exploring this topic, as I shared with some other lobbyists earlier today. That in my 4 years now, fourth year of being here, this certainly seems to be the most contentious issue among a handful of contentious issues I've seen. So there must be a lot of money involved here, and I think it's an issue that we need to spend some time exploring. And I thank you, Madam Chair, for having a second hearing on this issue. Are we going to hear from any lobbyists?
Yeah, there are 3 people signed up.
Yeah, they're signed up.
For
Okay. Well, and I'll go ahead and address this question if I may. You can speak to it, and they may want to speak to it. When I toured Northeast Georgia last year, I remember one of the things that really just stood out to me, among others, but was that the number of beds taken up in the ER with mental health patients. And so, I look forward to, I would love to see it addressed, maybe by you and by the lobbyists representing the hospitals. What kind of impact could this make in helping free up some beds in the ER? The second question I would have, if I may, Madam Chair,
Sure.
is what is, because I'm sympathetic to the other, the other side that's going to speak today, to them accepting, the hospitals accepting indigent care. But what is the actual cost? We hear figures that I've asked for in the past of, they say, well, we have so much,
When you say the actual cost, you mean of providing the care to the individual within the hospital?
The indigent care that the hospitals are forced to accept.
I'm not sure that I could address that issue, and I would think that would vary from hospital to hospital. Each hospital has its own setting. So, and back to your first question, can you repeat that for me? I'm sorry.
First question is, what, as you kind of alluded to that, one of the reasons you brought this bill is that you see a lot of need across the state for mental health. And I would love to hear what kind of, when I toured Northeast Georgia, one of the things that they brought up is the number of beds that are being taken, and just the huge need that we have for mental health care.
Well, quite frankly,
With bringing the
sorry.
private sector and remove CON, what kind of positive impact or negative would that have on the hospital?
Sure. Well, what's happening currently is that there's not a mental health facility in the local area, so the family is taking them to the first hospital they can get to. They don't have an an alternative methodology for dropping their child off, their adult child off, their wife, their husband, whatever it is. They have no place to drop them off. So they're going to the nearest hospital facility because that's the only place available to them. When you have to drive an hour and a half to get to the nearest mental health facility, most people are not going to take that chance if they have someone that's not acting properly. They're going to go to the closest place that they can be restrained. In many instances, the sheriffs are called out, the local police chiefs or the local municipalities police are being called out, and they're the ones who are having to restrain. And my sheriff in my county said that they are the largest mental health facility within the region that we're in. They said they are the first stop for most mental patients, for families who cannot figure out what to do with someone who's not acting properly.
Representative Clark, I think what you're asking is the only way it would help hospitals with their overloading of mental health patients would be if there were private patients that were out in the halls or whatever problems they were having, and that private patients had another place to go, then that would maybe free it up. But the hospitals do have to take the indigent. But I will remind the committee off CON, and I'm not going after the hospitals, but the hospitals are tax-free. They're not taxed on their land. They're not taxed on what they buy. They don't, so they don't pay a tax on what they are tax-free. And for that, we do expect them to do indigent care. And there has been a reimbursement for indigent care. Under Obamacare, it's supposed to phase out, but with things changing, it may not be phased out, but it is in the plan to phase that reimbursement out gradually. So that would be the only thing. Thank you very much. We'll go to the public. Thank you. Okay. Ethan James. Sure.
Thank you, Madam Chairman. Members of the committee, I'm Ethan James. I'm with the Georgia Hospital Association, and we represent more than 170 hospitals in the state of Georgia, from these small rural critical access hospitals all the way up to our large urban multi-hospital systems. We do represent the not-for-profit hospitals as well as the for-profit hospitals, and Madam Chair, just a point of clarification, only about 2/3 of the state's hospitals are not-for-profit and don't pay those taxes.
Okay.
About 1/3 are tax-paying entities.
The private ones, like HCAs.
Correct.
Okay.
And some other facilities. We also count among our membership all of the mental health facilities, not the state mental health facilities, but the private and the not-for-profit mental health facilities. And interestingly enough, none of those hospitals, and we polled them all, none of those hospitals do support this legislation, even though it would reportedly help them expand or open up in new markets. They don't believe this is a good idea. Madam Chair, if I could, I would like to turn it over to Carrie Conley, who is also with the Georgia Hospital Association. She's our Associate General Counsel, and she's going to speak more about the details of CON and access to care for our state's most vulnerable patients.
But before you turn it over, did they give you a reason they didn't support it? Was it just the fact of just a blanket CON change?
Well, of course, we do get kind of prickly about CON, and I'm sure the committee can understand why. But they recognize that this is not the answer, especially for our indigent and underinsured patients, because this would be private pay. They wouldn't be able to bill for the ABD, the age blind disabled Medicaid reimbursement.
But-
these facilities just do not see the need to open up in these markets without CON, without going through the CON process. We do believe that that is an important part of the process, and we have spoken to the author and expressed our concerns, and we do believe, with all due respect to the author, we do believe this stems from a local issue.
Mr. James, when we have these discussions on CON, it's always about the indigent patients. Do private paying patients and just the regular average Joe who pays their bills and has insurance, do we not have concern about them? We had a representative, and because I'm in healthcare, who had an issue recently of needing not the representative of psychiatric care, but a family member. And the first thing the private hospitals asked was, is this person 18 or under? There were no beds for young people. Luckily, the person was older, and just luckily, there was a bed available for this situation for a private patient. I understand about the indigent and I care about them, but sometimes we got an awful lot of people in the state of Georgia who are not indigent, who have insurance, and when they are mentally ill, there is no place for them to go. And so I would just ask our hospitals not just to look for poor people, which I am very concerned, and I think you know that they get care. But we've got an awful lot of other citizens. And mental health is one of the places where there are not a lot of places to go, and often, especially for adolescents, you cannot find a bed. I mean, I've had several calls for parents in my district when they have a young person that's totally out of control and they're trying to get them help and can't find a bed. So it's just, I know the hospitals are concerned, but sometimes it just gets old only hearing about the indigent and people on Medicaid and all. There are instances when other people need help also.
Yes, Madam Chair, and of course, we do care about all the state's patients.
Okay, thank you.
Just to be clear. Gary, thank you.
Thanks, Ethan. As Representative Stover mentioned, there is a company in his district that has filed a CON application and has recently been denied. And that project is ultimately what prompted this legislation. Now, I think it's important to keep in mind that that's still an open issue, that project. This is an ongoing legal dispute. It's currently in appeal, and it very well may ultimately receive a CON before the day is done under the current process. So we're talking about not a simple change, maybe a simple change word-wise by adding just one little word, but a major overhaul to the CON process as the result of an ongoing legal dispute that we don't know the outcome of yet. And given the current environment, we just don't think it's prudent at this time to be making such a major change to the CON process or to any healthcare process for that matter, just for one localized area of the state during an ongoing legal dispute. I'm going to give a little bit of background on the CON process that some of you may be aware of already, but I know that we have some newer members as well, so bear with me. In 2006, the General Assembly created the Commission on the Efficacy of the Certificate of Need program in Georgia. In its final report, the Commission, which did recommend a number of changes to the CON program, also unanimously recommended that inpatient psychiatric and substance abuse services continue to be regulated by Certificate of Need. Just last month, the Senate Study Committee on Independent Physicians in Georgia, which was mentioned earlier, unanimously recommended that no action be taken regarding Georgia's CON program at this time. This study committee was primarily focused on a different type of healthcare service, but the committee's conclusion is applicable to all types of healthcare services, including mental health. Specifically, the Senate Study Committee concluded, and I'm going to read directly from their report now. With the ACA, the Affordable Care Act, taking effect January 1st, 2014, the significance of the effects the ACA will have on the state's healthcare systems and patients is yet unknown. Therefore, no changes should be made at this time that could negatively interfere with the ability to independently evaluate the effects of the ACA. The current CON exemptions for state mental health facilities, which were included as part of SB 433, a comprehensive CON reform bill passed in 2008, which resulted from intense multi-year negotiations between all stakeholders. HB 853 has had no such stakeholder meetings at all. The current exemption for the state facilities already gives the state the tools it needs to ensure access to mental health services for Georgia's most vulnerable populations. And this is an area some of you had some questions about for Representative Stover, and I think we're getting a little bit confused between two separate issues here. The addition of private mental health facilities in the state is not going to serve to help reduce the problems that we're seeing in the EDs, in the emergency departments, in Georgia and across the country. That's because most of the patients waiting in those emergency departments are indigent patients, and they're waiting on a bed or to receive services through the Department of Behavioral Health and Developmental Disabilities. Now, GHA and our member hospitals are working really closely with Commissioner Berry and the Department of Behavioral Health to find a solution for this extremely complex issue. But it's just that, it's complex. And the addition of private facilities doesn't help for a number of reasons. Private, freestanding inpatient psychiatric facilities under federal law cannot participate in Georgia's Medicaid program. So even if they want to, and we actually have a number of members that are private freestanding facilities that are dying to participate in Medicaid, but they can't under federal law. The State Department of Behavioral Health provides inpatient services for the indigent through a variety of means. The state hospitals that remain open, the crisis stabilization units, which are run by local community service boards, newly developed behavioral health crisis centers, and a very small number of private beds that they have under contract in a pilot program in North Georgia. But for the most part, these patients that are waiting in our EDs do not have the ability to go to private freestanding psychiatric facilities. So I want to make it clear that we're really talking about two separate issues here.
That's what I tried to clarify by
Exactly.
saying that it wouldn't make a difference, maybe than to take a private paying patient out of the hospital.
Exactly. So just to wrap up, HB 853 does not address the mental health needs of Georgia's citizens at a statewide level. It's an attempt to intervene in an ongoing legal dispute, and on behalf of our hospitals, GHA opposes HB 853 and any other proposal to weaken Georgia's Certificate of Need law. Thank you for your time, and we're happy to answer more questions.
Any questions? Okay, Representative Clark.
You mentioned, thank you, Madam Chair, you mentioned it not being a prudent time at this point. When do you envision, and I ask this as an honest question as a second-term legislator looking at this issue, hearing it for the second time, when would you honestly think this would be a prudent time to look at this issue? And several years ago, when you said all the stakeholders came together, the picture that I've received from certain people I've talked to, and I want to make sure I'm getting an accurate picture, is that the hospitals, which I'm thankful for, got some great hospitals in my district, and I'm hugely supportive and want to do everything I can to support them where I can, and when it's in the best interest of not only my district but the entire state of Georgia. But were you guys supportive of that when there were changes? You say comprehensive changes to CON laws a couple years ago.
Kicking and screaming.
Two questions for you. When's a prudent time?
Well, to answer your second question first, we did participate in some of those negotiations, and ultimately there was a compromise that came out during the 2008 session. Going into that discussion, no, we were not supportive of those changes, but we did come to the table and were able to reach a compromise agreement.
And they did because of that. That area, Noonan has the new cancer center hospital, which did agree to see, they can see Medicaid patients, and I think they agreed to do a 35-65
That's
match.
inpatient, outpatient, in-state and outstate.
Okay. Oh, okay.
But not a Medicaid formula.
Not a Medicaid formula, so they just took the patients. They do have a Medicaid requirement.
Right, but not the 65-35.
Oh, okay.
Well, I'd like to thank you on behalf of the what's that called, the American Cancer Centers of America.
Cancer Treatment Centers of
I have a number
America.
of constituents who have come to me and very thankful for that facility, so I'm glad that came out of it.
Your other question was, when is a good time?
When is a prudent time to consider? I just keep hearing it's not prudent now. That last year, and I keep hearing that. When is a prudent time?
As we work through the comprehensive, or the very complex and comprehensive changes that are coming with the Affordable Care Act, I think we need to see the exact effect on our state and our state's patients and our state's healthcare facilities before we can really consider any other changes.
Okay. I'm certainly not against hospitals. And Josh, did you have to pick Northeast Georgia? Since I'd already picked on Deb, which I have known her for years and years and years. But anyway, I would say that to the hospitals, there are changes coming, but one of the changes with the Affordable Care Act is that more people are going to have access to mental health care, and because it's a requirement of that law. So, we may need something, and this is private. It's not something that would, necessarily hurt the hospitals. And the other thing, there are some more bills coming, apparently, where there are different kinds of hospitals, and where some small hospitals may go out of business if we wait 2 or 3 years and the changes that are needed. I mean, I'm not in favor of this bill. That's why it's having a hearing. I think it's too broad. But I do think that, especially in the rural areas, rather than lose some of the rural hospitals because we're waiting, that very narrowly drawn changes might be necessary. And things that would be like freestanding emergency rooms, which would be in conjunction with hospitals owning them, but just in a different kind of arrangements. So with Representative Clark, I do think we need to have some of the discussions, and that's why I'm giving the bill a hearing. I'm not against hospitals. I just think that healthcare is changing. It's changing for y'all, but sometimes things need to be done and not wait for some rural hospitals to go out if we can find a way to keep them open with small changes to the ceiling. Because I know you think we're picking on you.
We don't mind being picked on. But to your point, Representative Cooper, there are changes coming to all aspects of the healthcare system. Hospitals and physicians and everybody are just, underwater right now, kicking their legs as hard as they can, trying to figure out, keep their heads up and figure out what's going on. To your point about the additional reimbursement for mental health services, that's absolutely right, and that may initially create an uptick in the amount of patients who have private pay insurance for inpatient psychiatric services, but ultimately, hopefully what it will do is get some of those people into treatment before they get to that crisis level. So this is one of those points where, yes, there's a huge amount of change coming. We just don't know what the ultimate outcome is going to be. We don't know how it's going to play out. And I would hate to see us, make such a major change in the CON process in anticipation of something that 3 years from now it turns out that, oh, well, we were wrong.
Well, part of the things too that one of the dictates of that is the treatment for drugs and alcohol, and very often that is inpatient, and very often that is people. Representative Pack, if you'll quit moving, I need to. Representative Pack, can I talk to you about the other bill sometime while we're on the floor? I'm trying to see. If that goes and that holds, where are we going to put those people? because the hospital no longer has most hospitals do not have psychiatric units. The rest of them are full, and if we're required by that act to now treat alcoholism and drug abuse, and those need inpatient, those are the kind of patients. Sure, probably most of them are private patients, might not be schizophrenic and having breaks, but the Affordable Care Act, I know quite a bit about it, and the drug portion of it does include something that may need more long-term care and some beds on a longer period of time. And like I said, I'm not in favor of this wide open a bill, but I think we need to start thinking about that and the changes that are coming, and some of them don't affect the big hospitals or the hospitals and your bottom line. And I said nothing about reimbursement. So,
Madam Chair, you do bring up a good point about working toward some of these changes. That's why we do appreciate Commissioner Berry and the work group that he has established to address some of these changes and necessary changes and fixes for this mental health issue, the kind of changes that are needed that this bill would not address.
right.
So we do appreciate the Commissioner.
But he's looking more on indigent and Medicaid patients, not focusing on, here again, that I would say the largest percentage of our 10 million Georgians are not on Medicaid. I think it's about, what, 1/10 of, it's not a tenth of it even, like that. So, you know, the state agencies are working on that. Who's working on the other people? So, I mean, I have no problem if the hospitals want to go back like it was when I was in nursing school and we had psychiatric units at the hospitals where they open up some beds. If you want to do that and have a psych unit, go to it. But, I mean, when there are no beds, there are no beds for private paying patients. So I just think, here again, sometimes it's a little bit of a different aspect that doesn't go to the hospital's bottom lines. Sorry.
And Madam Chair, I think to your point about the private pay patients and needing to pay a little bit of attention to them, the Certificate of Need law, particularly as the rules and regulations that have been developed by the Department of Community Health relate to mental health services, I think sometimes we forget that it's not a complete ban on any new facilities ever. You know, there is a process in place that if a company can demonstrate need or a facility can demonstrate need for expansion or a new service, there's a process in place for that to happen. And that's exactly what's playing out right now in Noonan, and, you know, we're still waiting to see.
I agree, and that's why I brought it up, that it was a process. It's why it's a hearing, not moving on a bill, because I think it's too wide, and there is a process going on. But most of the time, there's a hospital fighting it. And I did say that it's based on a formula that is old. And, you know, more or less.
Just as a point of clarification, Madam Chair, there is a very specific formula for acute care hospital beds, but there is not a specific formula for mental health beds, for inpatient psychiatric beds. So it does make it a little bit easier on that end.
Gee, that's not what the commissioner told me, but I'll check it. I'm sure you know what's right, and I stand corrected. Okay.
Madam Chair, with regard to some of the other bills that you indicated may be coming and the rural hospitals, again, we don't believe that is a necessary change to CON. That may just be a licensure change.
That would be wonderful, but if it isn't, I mean, the hospitals were delighted to ask me to make a change in CON for them last year or 2 years ago, which I did and said I would not do anything different than what it was, or I would pull the bill. So even the hospitals have seen the need for a change. And sometimes that needs to, you know, it needs to happen, and it might need to happen on the other side to save some of our rural hospitals. And it may not be able to fix. I know, Mr. James, that you are working to try to look at that about the rural hospitals, but it seems when we think that we're going to be able to do it by rules and regs, it comes back to the fact that we need to change the CON laws. And like I say, we have opened them up. There are some of us that our word is pretty doggone good when we tell you we won't move it and that the only thing that's going through it's like it is. And if that comes down to it, I think the hospitals might get together and accept that fact. And as I've told you, if you're worried about it and we really do need freestanding, I'll be glad to carry the bill and give you my word just like I did when I carried the changes for the hospital.
Thank you, Madam Chair.
Okay. Representative Clark.
Thank you, Madam Chair. You mentioned that you represent a large
Yes, sir.
What percentage did you say?
Percentage?
Most of
Most of them. There are a handful of hospitals in the state that are not part of our membership for advocacy purposes. They are part of our membership for data reporting purposes, though.
So are there other private hospitals that, I mean, what percentage of them aren't, you mentioned that many of them are now are not in favor of CON, and the private mental health care facilities.
They're not in favor of changes to CON, right? My membership, yeah.
Your membership.
Yes.
This specific bill?
This specific bill, yes.
All right, which I've already said.
Or any other changes to CON. We stand united in that.
And you said majority of healthcare facilities represented by you guys.
That of hospitals, yes, not healthcare facilities. I mean, there's a number of other doctor's offices and nursing homes, but yeah, the hospitals, yes, sir.
And the Cancer Treatment Center of America,
that is not a part of our membership, no, sir.
They're not.
No, sir.
Why are they not?
Our bylaw.
You said earlier they were a part of, as a positive outcome of the CON changes?
I believe Madam Chair referred to that as a positive part of that change, but our bylaws do not allow for that type of facility. We just don't have a category for that type of facility. It's a destination cancer center, and we just don't have a category of membership for them.
It was a positive for that community.
It was what?
It was a positive for the community. And is it staying full, the state, I guess, in the area for people to come to?
They're adding 25 beds right now, and they're maxing out. They said they need more.
Thank you. No other questions? Thank you very much.
Thank you.
Okay, Deb, come on if you feel like it's safe. We're really not attacking you. It needs to be a discussion. Because, I mean, we've got hospitals in danger of closing in the rural areas. And despite what the press wanted to say twice, those communities need some type of hospital. They need that economic, engine for their areas. Maybe what they need is a psychiatric hospital. Maybe what they need is a rehab hospital or along with a freestanding emergency room so that they can get emergency care for their people. Okay, thank you. Hey, Deb.
Good afternoon. Thank you, Madam Chair, members of the committee. My name is Deb Bailey, and I represent the Northeast Georgia Health System Medical Center and Laurelwood Psychiatric Hospital. First, I would like to say I am a registered lobbyist. To stand in front of you, I have to be a registered lobbyist by law. However, I like to think that I am more than that. I am a master's prepared nurse. I'm a former psychiatric nurse. I was a head nurse on a drug and alcohol unit, and I was a head nurse on a psychiatric unit. In addition to that, I taught psychiatric nursing at Brunel University and have co-authored several psychiatric texts, as has Madam Chair. So I have a long history with psych patients, and so does Northeast Georgia Health System in Gainesville have a long history with psychiatric patients and caring for them and feeling like that psychiatric patients deserve the same care as every other patient that is ill, whether it's a mental illness or a physical illness. So we feel very passionate about this. However, with that said, I do still stand in opposition of carving out this piece for CON purposes. And the reason is and answer a number of questions along the way, too. We are the second busiest emergency room in the state of Georgia with almost 110,000 visits. We do have a lot of psychiatric patients in our emergency room. We've had a number of you visit our organization. We had the committee this summer, the Joint Study Committee on Mental Health Access, visit our organization and spend a half of the afternoon in our emergency room and in our psychiatric hospital, and actually cited a number of the things that we're doing there as exemplary in what we're doing in our system. But with that said, our psych hospital is 30% indigent and charity. And we feel if there are facilities that can build hospitals that would serve only paying patients, that would take the paying patients that we do have from us. And what that would do is our psychiatric hospital is currently being subsidized by our 561 med-surg beds and 261 skilled nursing beds. That subsidizes the psychiatric patients that we serve because we make no money on those patients. That means, Madam Chair, that 70% of the patients that we serve are some type of paying patient, whether that's a Medicare patient, a Medicaid patient, or some type of whatever's left of insurance, which is only about 30% now of the population that we serve in the 13 counties in all of our patients. So we feel like that it would not improve access, that it would hurt access, that it would actually jeopardize us being able to continue to subsidize our psychiatric hospital that we've had in place for probably over 40 years now, or close to 40 years. We were one of those hospitals that had a psych unit and then moved into a freestanding psychiatric hospital. So I'd be happy to answer any questions, but currently we are in opposition to.
Okay, Deb, I cannot call you
Miss Bailey. Yes.
Since you were my student.
Okay.
So, and went in psych, because that's a good thing. I'm glad I taught you well.
You did, Madam Chair.
And I have said this bill is way too open. But the reason we're discussing it is if it's in an area, let's say in a rural area where the hospital's about to go under, but they could use a freestanding emergency room where their patients could get care, but they could also use a private mental hospital. That wouldn't affect Northeast Georgia Medical Center, would it?
No, ma'am, and I wouldn't say that I was specifically, I am speaking specifically for Northeast Georgia Health System and Laurelwood. However, if we are to look at those type of things, everything related to the Certificate of Need process is always looked at globally across the state and the impact that it would have. And it's all part of the planning process. And I think anytime we look at that planning process, whether we're looking at increasing it or if with freestanding emergency rooms we're looking at decreasing it, we have to look at the impact on the system, not really, although I'm speaking on behalf of Northeast Georgia Health System. To answer that question, I'd have to speak on behalf of the state. And I do think that we would have to look at the impact that that would have.
Well, I think it needs to be just looked at and an openness to it, at least in areas where there's not competing business and where there is need for repurposing of some hospitals and different things, at least that we can be open to looking at some of the needs of real people. I also am not sure if anybody knows that study group, did it focus mainly on indigent care and people unable to pay?
It focused on, actually this was a joint House and Senate with, I'm sorry that Representative Dempsey is not here, she did co-chair that commission, and they went across the state and they looked at the scope of access to care.
Okay,
and there was never once was this discussed during those periods of time, once being CON.
Okay, like that. Representative Watson.
Thank you, Chairwoman. Ms. Bailey, Northeast Georgia is a not-for-profit, right?
Yes, sir, we are.
And so you have 30% indigent or uninsured, I presume? Is that what you're 30%?
That's correct, in the Laurelwood Psychiatric Hospital.
All right. And so what's the breakdown at Northeast Georgia? I mean, I know, you know, in Savannah, Memorial has which is the quote-unquote indigent hospital there, has a 18% Medicaid and 20% uninsured. The rest are either Medicare or insured. What's the breakdown in Northeast Georgia?
Right now we are, for the health system, the 557-bed community med-surg not-for-profit hospital, we are approximately 40% Medicare, about 15 to 17% Medicaid. We are about 12% indigent and charity, which is equal to about $35 million that's written off uncompensated each year. So that actually leaves us somewhere, and I'm not doing the math, I'm just kind of saying that these are, you know, I can get the exact numbers for you, but so that leaves us with about 30 to 33% of an insured.
Okay.
But as you
private insurance. Right.
Yes,
Gotcha.
but as you well know, as things have changed, private insurance, although it does cover a number of things, as people choose and opt in to the high deductibles, the $5,000, the $10,000 deductible, just as your office is probably losing money on that, most of those folks are not paying those deductibles as they leave. So even though we have the indigent and charity, we also have a huge amount that's not in there that's uncompensated that are insured.
So how much disproportionate share of funding do you get per year?
I think last year total maybe $6 to $7 million, and the $33 million that I gave you was net. That.
And the so there's a not-for-profit portion in Northeast Georgia, and there's a for-profit portion.
Absolutely not. There
so
are no.
Not. Gotcha.
No, sir.
And so do you count do you subtract the amount of taxes that you don't pay or the tax breaks that you don't get on the property taxes and so forth?
We've studied what we have, what our tax benefit as a community not-for-profit is, and we have found as pretty similar as it is across the state, that is for every, it's 4 to 1. You get back $4 worth of benefit for every $1 in tax break that we receive.
All right, thank you.
Okay. I have a question for you. It's my understanding from when somebody told me about the hospitals that when you do the indigent care calculation, that unlike you do when you negotiate with an insurance company and you say something, the bill is $50,000, but you break it down to $10,000, that when the indigent care number, there is no deducting it down. You just charge what the first number was, which you don't get from other people. Understand what I'm saying?
I do understand the question.
I wasn't doing very well on that.
I'm not sure that that's correct, because oftentimes you already have given that indigent population a discount, because at that time you don't know that they're indigent, and they're maybe going to try to pay a portion of their bill. Now, there are a group that's indigent from the beginning.
That's the one I was talking about.
But often the indigent comes later on in the process, and that's already been discounted.
Okay, thank you. Other questions? Thank you for letting us grill you a little bit.
Thank
you.
you.
Well.
Thank you very much for your attention.
Come on, Tim.
Thank you, Madam Chair. My name is Tim Kibler. I'm with the Georgia Alliance of Community Hospitals. We're a 65 hospital organization, and all of our hospitals are not-for-profit hospitals. We adamantly oppose Representative Stover's bill. We had a brief chance to talk this morning about our concerns, and I offered him at the time that we would love to work with him on the criteria that DCH uses to examine the appropriateness of placing a facility, but that in fact there's no way we could ever support blanket elimination of the CON for private psychiatric hospitals. Be glad to go into whatever level of detail you'd like, but I think you've heard from my colleagues who are far more articulate than I that this is the reasons for our concerns.
Well, thank you for being open and being willing to work with him and not just saying no. Thank you. Is there any question? Representative Kaiser.
Thank you, Madam Chairwoman. I just had a question out of curiosity, and Representative Stover, you may have to answer this, but what was the reason given by the Department for denial, and then what does the bill look like as far as the intended success or problem?
With regard to that facility, there were several reasons. Number one, they said that their charges were too high. They were going to charge $1,500 for that versus $963. They said that Tanner was located too close to the facility, which was it was only 20 miles away, which is a 45-minute drive, to be fair. So those were two of the major concerns that they had. That hospital, I'm 99% sure will be approved because of the company who buying it has a local. So that is not why I'm presenting this bill. This bill is presented so we can increase mental health.
Representative, I don't think I would have said that. Is there a filter? Maybe I don't have a filter either. So.
Yeah, Madam Chair, we hope that serving the unserved population would be the basis for the hospital to be placed, not the pull of the company.
Right. Okay, thank you very much. No further questions? Wait a minute, do we have somebody? Is that Representative Clark, you had a question? I'm sorry.
Oh, I'm sorry.
Madam Chair, thank you. And perhaps this is what you were asking. I was too slow to catch on. Maybe it was just addressed. When I hear the percentage of indigent care, I kind of brought this up earlier, and I'd love to maybe you could help me out with this. Is that, when y'all talk about a number that a hospital loses in indigent care, is that number what the amount that you put on, that you place on that service or procedure or medicine, or is that the actual cost to your hospital?
Madam Chair, I'm not sure I'm the right person to answer that question. I don't work for a specific hospital. I think the billing procedures differ but comply with federal and state law. It's been always my understanding, though, that what we're talking about in our payments is against cost for Medicaid, which is the money that the hospitals receive for serving patients. They pay only a percentage of cost, not a percentage of what's billed.
Okay. We can probably, Representative Clark, we can probably ask. Deb, would you work on finding that out for us? And
Yes, ma'am. And in addition to that, different hospitals have different set standards for indigent care also. You're allowed to go up to like 400% of the federal poverty level to have.
thank you. Is anybody else in the audience? I think we have somebody else who wants to speak to this. Come on up. Identify yourself. I know who you are.
Thank you, Madam Chair, and thank you for your continued support of mental health. It's meant a lot over the years. I'm Ellen Yeager. I'm with Mental Health America of Georgia. I represent absolutely nobody with money. So I'm here representing consumers of mental health services, and we see things a little differently. First of all, I'm sorry that Representative Kidd left because he brought up a really important subject when he was talking about people who are potentially can hurt others or themselves, and we do have something in process for that. It's a 1013, and there are hospitals that do take people who are 1013. So I would hate for you to leave thinking that somebody who is dangerous just walks out of the door. I would also like to talk about and thank Representative Stover, because it is bills like this that allow us the opportunity to talk about mental health and the needs of people who have mental health. What I'd really like to say is that for us, this is not about a CON bill. This isn't, we don't support the bill and we don't oppose the bill. What we'd really like to say is that what we're looking for is what the Department of Behavioral Health and Developmental Disabilities is doing is really what we are supporting. And that is looking at how do we get people early on? How do we get people before the crisis occurs? What do we look at when we're talking about early intervention and prevention? You know, we know that we have ACT teams in place. These are very positive. ACT teams are assertive community treatment teams that work with people who have mental illness. So for us, this is an opportunity to talk about what really does serve the mental health population. And what serves the mental health population is education, early intervention and prevention, and eliminating stigma. And again, thank you for bringing the bill. Thank you for hearing the bill. You know, for us, we're always ready to sit down and talk about what works for people who have mental illness. Thank you.
Thank you. Ethan, I have one last question for you. How many private hospitals, psychiatric hospitals, are there in the state? Approximately?
I want to ballpark it probably about 20.
Spread across the state? Would you do that and get that for me? So, and I'll circulate it to the committee so at least they can see where they are and have a little bit better knowledge of the availability of beds. Is there anyone else? If not, thank you to the committee for sticking with us, and thank you to everybody in the audience. Thank you very much. Huh?